Welcome to the House Criminal Justice Committee for Wednesday, April 21st. Madam Clerk, please call the roll.
Representatives Beck, Campbell, Dixie, Doggett, Farmer, Griffey, Hardaway, Hawk, Howell, Holsey, Lamar, Lamberth, Moody, Russell, Sherrill, Vice Chairman Sexton, Chairman Curcio.
Here.
Chairman, you have a quorum.
Thank you very much. Members, do we have any personal orders before we get started? Seeing none, we are ready to get started. We have got ourselves a full calendar today. We're going to start with item number 1, House Bill 1430 by Chairman Littleton. She is in the room. Madam, you are recognized. You have a motion and a second. I do see 2 amendments, so I'll just let you move which one you prefer.
Thank you, Mr. Chairman. Got in the room just in time. I think I want to move with, this is Representative Ogles, so I'm carrying it for him. I want to move with 7164, please.
Representative Littleton, Chairman Littleton moves amendment coded 7164. You have a motion and a second. Please describe your amendment.
This enhances assault by intentionally, knowingly, or recklessly causing bodily harm, injury against an adult domestic assault victim whose relationship with the defendant falls within the category of adults or minors who are current or former spouses, or adults or minors who are dating or who have dated or who have or had a sexual relationship if the bodily injury incurred by the adult domestic assault victim involves a broken bone, damage to the platelet, or the sensory function, including but not limited to the ears, mouth, eyes, nose, that requires medical repair or reconstruction, tearing of ligaments or muscle tissue, dislocation of joints, abrasions to the neck, face, or chest, or substantial bruising to the body, a Class E felony offense.
Members, you've heard the explanation of the amendment. Any questions for the sponsor? Seeing none, we're ready to vote. All those in favor of attaching amendment coded 7164 to House Bill 1430, please signify by saying aye. Aye. Those opposed, you adopt. We're back on the bill as amended. The amendment made the bill without objection. We're ready to vote. All those in favor of sending House Bill 1430 to Finance, please signify by saying aye. Aye. Those opposed, ma'am, you head to Finance.
Thank you, Mr. Chairman.
Thank you very much. Next up, that brings us to item number 2, House Bill 666 by Chairman Wendell. I apologize. Members, I see that this bill has been rolled to 2022 in Senate Judiciary, so without objection, I move we roll this to the first calendar of 2022. Yes, sir. Thank you.
Mr. Chairman.
Thank you, sir. Next up, item number 3, House Bill 1143 by Vice Chairman Grills is rolled 1 week. Next up, item number 4, House Bill 1102 by Representative Shaw. Sir, you have a motion and a second. While my good friend from Bolivar makes his way forward.
Thank you.
Thank
you,
sir.
Mr. Chairman.
Sir, you have a motion and a second.
And we have an amendment. I believe.
Representative, I have 2. The one that I think you want to move forward with is coded 7397. Is that correct?
That is correct.
Sir, you have a motion and a second on that. It makes the bill, so if you could please describe the amendment.
What the amendment seeks to do to eligibly expunge a person who was convicted of assault, a person who was criminal conviction was ineligible for judicial diversion at the time of sentencing. Is what the amendment does. It makes the bill.
Thank you, sir, for the explanation. First on my list, I have Leader Lamberth. You recognize?
Thank you, Mr. Chairman, and thank you for bringing the bill. I mean, this neither expands or contracts the individuals that are eligible for expungement or diversion, but it does allow for a greater time frame. And so instead of right at the very beginning is the only opportunity you could ever get expungement, this allows for this group of individuals that before had been precluded from being able to pursue this later when they had proven that they're, positive members of society and had cleaned up their acts. This is a really good piece of legislation. And again, I wanted to make it clear with your amendment, it again, does not expand or contract the individuals that are eligible for diversion. It just changes the timing on when they would be eligible. So good bill. Thank you, sir.
Question's been called on the amendment. Without objection, we're ready to vote. All those in favor of attaching amendment coded 7397 to House Bill 1102, please signify by saying aye. Aye. Those opposed, you adopt. Members, we're on the bill as amended. Any further questions? Seeing none, all those in favor of sending House Bill 1102 as amended to Finance, please signify by saying aye. Those opposed, sir, you head to Finance.
Thank you, Mr. Chairman.
Thank you, sir. Next up, that brings us to item number 5, House Bill 1121 by Chairman Farmer. Sir, you have a motion and a second. You're recognized.
Thank you, Mr. Chair. Committee, this bill does exactly what it says it's going to do. It's not been amended or anything. It says creates a Class A misdemeanor for a person to use fraud or deception to try to obtain confidential records concerning reports of child sexual abuse.
Chairman Farmer, thank you very much.
I believe.
Do not-
I may have been mistaken. It's not the first time today. It's not. So, Mr. Chairman, with your indulgence, I'd like to move House Amendment 4550.
The parliamentary position we find ourselves in is that Chairman Farmer has corrected himself, and he is now moving amendment coded 4550. You have a motion and a second. Any discussion on that amendment?
I think I was trying to trick Zachary into putting me on consent.
Excellent.
Really? But yes, sir, and that's what this amendment does. So,
Thank you, sir. Any questions for the sponsor? Leader Lamberth, you're recognized.
Would like to remind members that the chairman of calendar rules is watching. He is always watching. And when you invoke his name like that, you may or may not wind up on consent or on a Monday or a Thursday or a July calendar. But I am always cautious about invoking the chairman's name, and we will probably hear about this in the morning, this very conversation.
Thank you, Leader Lamberth. Yes, many of us have found ourselves behind the calendar before in that august committee. Members, we have a motion and a second. You've heard the description of the amendment. All those in favor of attaching amendment coded 4550 to House Bill 1121, please signify by saying aye.
Aye.
Those opposed, you adopt. Members, you've heard the explanation of the bill as amended. Without further questions, all those in favor of sending House Bill 1121 as amended to calendar and rules, please signify by saying aye. Those opposed, sir, you head to calendar and rules. Yes, sir. Next up, item number 6, House Bill 1319 by Representative Hardaway. Sir, you have a motion and a second.
Thank you, Mr. Chairman. There's an amendment 6721.
Sir, you have a motion and a second on amendment coded 6721. It looks like the amendment makes the bill. If you could please describe your amendment.
Thank you, Mr. Chairman. The amendment says quite simply, if practicable, a judge shall at the time of sentencing notify a person convicted of an offense that's eligible for expunction of the person's eligibility and the time period. The AOC shall provide the judges their cheat sheet.
Members, you've heard the explanation. First on my list, I have Representative Griffey. You're recognized.
Thank you, Mr. Chairman. Thank the sponsor for bringing legislation, but I have some questions and concerns. What happens if a judge fails to do it, and why can't we just have written information sheets, printed up flyers, whatever, available for defendants at court time, at clerk's office, posted around the courthouse, rather than putting additional burdens on the judge? Because I know some judges get busy. There's a lot of stuff going on in the courtroom. And that's my only concern. So thank you, Mr. Chairman.
Representative Hardaway, if you wish to respond.
Thank you, Mr. Chairman. The judges are doing it for misdemeanors. This merely adds the some of the other offenses, felonies.
Representative Griffey, any further commenters? Okay, thank you. Any other questions for our sponsor? I do have one, Representative Hardaway. I understand and actually support the spirit of this legislation. I'm curious, are you concerned at all about the situation where, the judge is going to basically set an expectation for someone to say, if you do all of these things right and you do everything the state has asked you to do, then at some point this will be eligible. But those things do change from time to time. Are you at all concerned that we set a level of expectation for someone and then they remember that conversation with the judge, but then down the road that particular offense is no longer eligible? Are you concerned about setting that expectation?
Thank you, Mr. Chairman. Actually, I'm not aware that we can be retroactive past the time of conviction and sentencing for expungements. So that's something I wasn't aware of.
Well, I mean, the list of expungable offenses does change, all the time. So I just,
Oh, okay.
Yeah.
Well, no, sir. The AOC is providing that list, and the reason that we put if practicable, so the judge can have the discretion on whether to do it or not to do it. If he or she has sufficient information and wishes to do it, the AOC will have the information in written form, ready for the judge to transmit that information to the individual.
thank you, sir, for the response. Any further questions for the sponsor of the amendment? Seeing none, we're ready to vote. All those in favor of attaching amendment coded 6721 to House Bill 1319, please signify by saying aye.
Aye.
Those opposed, you adopt. Members are on the bill as amended. You've heard the explanation. Any further questions for the sponsor? Seeing none, all those in favor of sending House Bill 1319 as amended to calendar and rules, please signify by saying aye.
Aye.
Those opposed? The ayes have it, sir. You head to calendar and rules.
Thank you, Mr. Chairman. Thank you, members.
Thank you. Next up, House Bill 1320, also by Representative Hardaway. Sir, you have a motion and a second.
Thank you, Mr. Chairman. I don't believe we have an amendment. So the bill, as it reads, sets punishments for gang recruitment, and it sets different classes depending of felonies, depending on the age. The most important one is a Class A felony if the victim is 13 years or younger. These gangs are recruiting children, and as you know, the longer they're easier to get, and the longer that they're in the gang mentality, the harder it is to get them rehab or to get them back into society as productive citizens.
Thank you, Representative Hardaway. Members, you've heard the explanation of the bill. I do have Representative Griffey on my list. You recognize, sir?
Thank you, Mr. Chairman. I just wanted to express my thanks to the sponsor for bringing this legislation. I think it's important legislation. We'll all support it. Getting yourself involved with a gang is just a sure way to ruin your life, And if we can keep people out of that, hopefully this will discourage some of that. So thank you, Mr. Chairman. Thanks, sponsor.
Thank you, Representative Griffey. Next on my list, I have Chairman Holsey. You recognize, sir?
Thank you. And to the sponsor, I think that's a novel idea. I just wonder if you could expand it and make it a criminal charge of trying to force somebody to take a vaccine against their will.
Question has been called on the bill. If there's no objection, we're ready to vote. All those in favor of sending House Bill 1320 to Finance, please signify by saying aye. Aye. Those opposed? Sir, you head to Finance.
Well played, sir.
Next up, that brings us to item number 8, House Bill 1323. Representative Hardaway, do you have something to say on this bill, sir? All right. Members, I will point out that this bill has been rolled to the first calendar of 2022 in Senate Judiciary. So without objection, we will roll House Bill 1323 to the first calendar of 2022. That brings us to item number 9, House Bill 1183 by me, and so I will send that down to our Vice Chairman. Thank you, Mr. Chairman. I also have an amendment coded 6744 I wish to move.
You have a motion on the amendment and the bill itself, and then the amendment 6744. We're voting on the amendment. Any questions? If not, all in favor of the amendment, let it know by saying aye.
Aye.
Opposers, no. That motion carries. Amendment goes on to the bill. Chairman Curcio, you recognized on the bill as amended.
Thank you, Mr. Chairman. Thank you, committee. Members, I've explained this in sub, but for those who were not on that committee, I'll start again. But this bill was brought to me by one of my public defenders, Travis Jones, and seeks to clean up a process that is already in current law. So when a judge sentences someone to probation for more than one offense, the judge sentences the defendant to either concurrent or consecutive probation sentences. Concurrent sentences are intended to be served at the same time, while consecutive sentences must be served one after the other. If an offender's probation is revoked and the two sentences are to be served in the same jurisdiction, The process is relatively straightforward. The offender either serves the sentences at the same time or back-to-back. Unfortunately, for offenders with probation sentences in multiple jurisdictions, the separate sentences do not officially begin until each judge revokes probation. This glitch in the system leads to an enormous loss of both time and money spent transferring offenders from jurisdiction to jurisdiction in order for their sentences to be officially revoked. For concurrent sentences, these transfers and delays in the judicial process mean that an offender could end up serving more time than their sentence authorized. For consecutive sentences, this issue does not always create such an extension because the offender must still be transferred to the new jurisdiction to serve out the remainder of their sentence. So this bill, as amended, seeks to patch this glitch by crediting any time served on a probation revocation towards any other concurrent probation sentence that is subsequently revoked in any other jurisdiction. The intent of this legislation is to make concurrent sentences truly what they are meant to be, concurrent.
Thank you, Chairman. Is there any questions? I have one. Representative Dixie, you're recognized.
Just for clarification, and so that I can have it straight in my mind, I think this is a great, excellent bill because it'll save a lot of people time and money and that heartache of jail time. So if someone is on probation they're in jail, or they get their probation revoked in Dixon County, but they're also on probation in Cheatham County at the same time. Mm-hmm. Instead of having to go through the process of serving your time in Dixon, then going to Cheatham, this can, and then because one is going to trigger the other one to be revoked. That's just how it is. So now, if it gets revoked in Dixon, it'll your time will still run under the other probation.
Thank you, Mr. Chairman. Yes, if it's concurrent, this just truly makes it concurrent. That's right. That's exactly right.
Okay, great. Thank you.
Thank you. Any other questions? Question has been called. No objections. We're voting on House Bill 1183 as amended. All in favor say aye.
Aye.
Opposers, no. Motion carries. The bill will move on to calendar and rules, and I'm going to pass the gavel
Thank
down
you,
to
Chairman.
our
Thank you, Committee.
Chairman.
Members, with no other business before the committee, we are adjourned, or so moved.